Good morning, this is your Kelso Report for Tuesday, April 24th, and I'm your host, Clark Kelso. Our cases today are in the areas of habeas corpus, immigration, bankruptcy, criminal procedure, procedural due process, and appellate procedure. We begin with a habeas corpus decision from the Ninth Circuit. In Maris v. Sisto, the defendant appealed the denial of his petition for a writ of habeas corpus, claiming that his Sixth Amendment right to confront witnesses was violated during his state court trial when the trial court admitted into evidence a forensic report without requiring the appearance and testimony of the person who prepared the report. At the time of his conviction and state court habeas filing, the Supreme Court had not yet resolved the question of whether such a forensic report was testimonial and therefore subject to the Sixth Amendment. In fact, the lower federal courts were quite clearly split on this issue at the time, and the Supreme Court did not resolve it until its decision in 2009 in Melendez-Diaz v. Massachusetts. Because the issue was unresolved at the time of the first state habeas decision, the federal courts cannot now say that the state court unreasonably applied clearly established federal law in rejecting the defendant's habeas claim. And under the Anti-Terrorism and Effective Death Penalty Act, the possible reasonableness of the state court denial under the law applicable at that time is, of course, sufficient to require then denial of a subsequent federal habeas petition, even though the law by now has become clear. Next, we have an immigration law decision in Robles-Urrea v. Holder. The Ninth Circuit held that misprision of felony is not categorically a crime involving moral turpitude. The case involves a lawful permanent resident who petitioned for review of a decision by the Board of Immigration Appeals concluding that he was removable because his conviction for misprision of felony categorically was a crime involving moral turpitude. Now, a crime involving moral turpitude is either one that involves fraud or one that involves grave acts of baseness or depravity, such that its commission offends the most fundamental values of society. It is not enough that an offense contravenes societal duties, the standard which was used by the Immigration Board, because if that were the standard, every crime would involve moral turpitude. Instead, only truly unconscionable conduct surpasses the threshold of moral turpitude. Misprision of felony simply does not satisfy this heightened standard. In particular, unlike certain other crimes of concealment that have been found to involve moral turpitude, misprision of felony does not require a specific intent to conceal or obstruct justice, but only knowledge of the felony. It is therefore not as culpable as other crimes found to involve moral turpitude, and for this reason is not categorically a crime involving moral turpitude. Next, we have a bankruptcy decision. The Ninth Circuit interpreted the application of California's homestead provision in the context of a foreclosure sale during a Chapter 7 bankruptcy proceeding in Re Myrna Jacobson. Under the applicable law, a bankruptcy filing does not stay a foreclosure proceeding on the debtor's principal residence, even if it is declared the debtor's homestead, so long as the proceeds of the sale would be enough to pay all outstanding claims, plus leave the debtor with a defined amount. In this case, the debtor was left with $150,000. Under the homestead law, that $150,000 is considered exempt from claims in bankruptcy unless the debtor fails to reinvest that money in a new homestead within 6 months. Well, Myrna failed to reinvest in 6 months, and so the trustee asked for a turnover order for the $150,000. Applying the so-called snapshot rule, pursuant to which the exempt or non-exempt status of property becomes fixed at the time of the bankruptcy filing, the lower courts held that the $150,000 was still exempt from claims in bankruptcy. But the Ninth Circuit reversed, holding that the state's homestead law at the time of the bankruptcy filing made the $150,000 only conditionally exempt, and that by failing to satisfy the condition, the debtor lost the protection of the exemption. Now we have a decision from the California Supreme Court in a criminal procedure matter. A criminal defendant who tenders his or her mental state as a guilt or penalty issue waives the Fifth Amendment privilege against self-incrimination and the Sixth Amendment right to counsel to the extent necessary to permit a proper examination of that mental condition. To afford the prosecution a fair opportunity to rebut mental state evidence proffered by the defense, a recent amendment to California's criminal case reciprocal discovery statute specifically provides that when the defendant places in issue his or her mental state at any phase of the criminal action, the prosecution may seek and obtain a court order that the defendant submit to examination by a prosecution-retained mental health expert. In Maldonado v. Superior Court, the California Supreme Court held that, as a general matter, neither the Fifth nor the Sixth Amendment requires trial courts to impose any special protective measures to ensure that the prosecution does not misuse information it learns about the defendant's mental state as a result of an examination of the defendant by the prosecution's mental health experts. Now, the Fifth Amendment clearly protects defendants against any direct or derivative use of his statements to the prosecution examiners, except to rebut any mental state evidence he presents through his own experts. But neither the Fifth nor Sixth Amendments requires anything more than that, and the California Supreme Court unanimously reversed the additional procedural protections that had been devised by the Court of Appeal in this case. Next, we have a case involving due process and low-income housing. Excuse me. The question presented to the Second District in Anchor Pacifica Management Company v. Green was whether a management company operating a senior apartment complex developed with assistance from a local redevelopment agency and subject to agency oversight must identify good cause when it evicts a tenant participating in the agency's housing assistance program upon expiration of the tenant's lease. Reviewing the history of the low-income housing assistance program, the degree of city involvement and oversight, and the law of state action, the Second District held that the plaintiff's eviction from government-subsidized and regulated low-income housing did indeed constitute state action that deprived her of a protected property interest. And as a result, the defendant landlord could not terminate her lease without making a showing of good cause. Next, an appellate procedure issue. In Fleur de Lac Estates Association v. Mansouri, the Third District had, in an earlier writ proceeding, directed the trial court to enter an order denying a petition to compel arbitration that had been filed with the plaintiff, but left open the possibility that the plaintiff could file a new petition to compel arbitration. On remand, the defendant sought attorney's fees and costs based on the Third District's decision ordering the denial of the first demand for arbitration. Well, the trial court denied the request for fees on the ground the motion was untimely. The defendant then moved for reconsideration and for relief under Section 473 of the CCP on grounds of excusable mistake, which the trial court also denied. Defendant then appealed those denials. Well, the frustrated defendant now learns from the Third District that there is no appellate jurisdiction to review those denials. According to the Third District, its prior remand left open the possibility that the plaintiff could file another petition to compel arbitration, which the plaintiff did file. Accordingly, there was no final judgment below from which to appeal, and the motions for reconsideration and relief under Section 473 were appealable only if they related to a final judgment. The Third District also refused the defendant's request to treat the appeal as a writ petition, So the defendant finds himself back before the trial court with nothing to show for his attempted appeal. And that's it for today's Kelso Report. Have a great day in the law.